My name is Mark Dsouza and I'm an Associate Professor at the Faculty of Laws, UCL. This is a presentation about an issue on which there is a lot of disagreement. So let's start with some points on which most people agree. Consent matters when deciding whether sex is criminally wrong. B's consent to sex negates the actus reus of a criminal offence, and D's belief, or in this jurisdiction, reasonable belief, in V's consent negates the mens rea of the offence. Most also agree that consent is an exercise of sexual autonomy, the authority to choose for oneself whether and in what circumstances one will engage in sexual activity. And V's exercise of sexual autonomy to grant putative consent is vitiated when she lacked competence, or acted under compulsion, or acted under a misapprehension of relevant facts. I'm focusing on the last of these three factors today. So, when, if ever, does the falseness of a belief that V holds render sexual activity non-consensual despite V's seeming consent? This is an important question. The non-consensual nature of sexual activity is a necessary condition for holding D criminally liable. Other things matter too, whether D acted with mens rea or had a defense, etc. But my focus here is on whether the sexual activity was non-consensual. Again, there is some basic agreement on foundational points. Since consent is an exercise of sexual autonomy, most people think that a good answer must be one that protects sexual autonomy while generating plausible outcomes when translated into criminal law. But here the major disagreements start. Strongly protecting sexual autonomy appears to come at the cost of generating plausible outcomes and vice versa. For example, you might think, and some do, that to truly protect V's sexual autonomy, our rule should be that if at the time of sexual activity V was mistaken as to any deal breaker belief, a belief that if V knew it was false, V would not have consented to sexual activity, then legally V did not consent. Call this the subjective deal breakers view. Now this view offers the most protection to V's sexual autonomy, but under it, every mistake, no matter how seemingly trivial or unrelated to the sexual activity, could potentially invalidate V's putative consent if V, however capriciously, decided to treat that matter as a deal breaker. So, if these matters were important enough for V, then her false belief as to the state of D's bank balance, or religion, or zodiac sign, or favorite band could render her seeming consent invalid. A mens rea-based denial of criminal liability may still be available to D, but even so, we might think that this spreads the potential net of criminal liability too widely to be plausible or practical. Now we might correct for this by enumerating key features, false beliefs as to which will vitiate seeming consent. Maybe we'd identify these by reference to objective policy considerations like clarity, coherence, predictability, and practicality. Only mistakes about these objective deal breakers would then vitiate consent. Now, depending on what made it to our list of objective deal breakers, these mistaken beliefs as to the nature of the impugned activity, her partner's entire identity, some legal status such as marriage, those sort of things might have this effect. But I've skated over one big difficulty with this approach, of course. There are seemingly intractable disagreements about what should make it to our list of objective deal breakers. Moreover, in all of this, we've lost track of our goal of trying to protect V's sexual autonomy. That is relegated to, at best, a secondary consideration. So, what is the best way to approach this question? I'm going to suggest that we can protect V's sexual autonomy and reach plausible outcomes if we pay due attention to two things. A, that valid consent is often given through exercises of sexual autonomy that are, to a greater or lesser extent, unreflective rather than considered. And B, that a belief can define both the object of consent and a precondition for it. My overall proposal is on this slide, so you can have a glance at that, and that's what I will be building up to. But for now, let's start by thinking about the manner in which we give consent. Now, when you engage in consensual sex, it is possible that you have thought through how you will exercise your sexual autonomy on this occasion by evaluating the pros and cons, and what I'm interested in here, reminding yourself of the beliefs that you hold which have led you to the point of consenting to sex. Perhaps you consciously reminded yourself of your belief that your prospective partner is single, owns that lovely house, is Muslim, does not have chlamydia, and genuinely loves you. But let's be honest, this considered analysis is not how it usually goes. More often, you make at most a very attenuated, almost subconscious calculation when engaging in consensual sex. It will either just feel right or not. Now, such a decision to engage in sex is a deliberate mental act that generates valid consent to sex. The courts have somewhat inaptly described this decision-making process as largely visceral rather than cerebral, owing more to instinct and emotion than to analysis. I use the terms unreflective and considered instead of visceral and cerebral to capture the same meaning. Now, to be clear, I'm not suggesting that individual grants of consent are either entirely considered or entirely unreflective. Most are some combination of the two. Nor am I suggesting that purely physiological responses to stimulus, such as getting an erection or becoming lubricated, suggest unreflective consent. Even unreflective consent involves making a choice in relation to the sexual activity. The difference between considered and unreflective consent lies in whether we deliberates about this choice intellectually or chooses emotionally and instinctively. But whether granted unreflectively or consideredly, consent is an exercise of sexual autonomy, and autonomy cannot be exercised through uncontrolled physiological responses to stimuli. Now, despite the ubiquity of unreflective agreements to sex, legal and theoretical analysis almost always implicitly employs the paradigm of considered agreements to sex when considering whether the falseness of a belief undermines consent. This isn't just a matter of focusing on considered agreements to the detriment of unreflective ones. The very possibility of unreflective agreements goes entirely unacknowledged. More concerningly, insights drawn from this sort of analysis are not confined to cases involving considered agreements to sex. In other words, it is assumed that a rule drawn up by reference to the paradigm of considered agreements to sex applies to all agreements to sex, including unreflective ones. Now, to see why this is a mistake, first examine a sort of considered agreement to sex. I call this example surprise. V agrees, despite not being in the mood, to have sex with her partner because she calculates that doing so would keep their relationship strong and make D happy. The ensuing intercourse is good, even unusually good. D pleasantly surprises V with some new moves. Now, while V's consent to the sexual intercourse as a whole was considered, it was based on a calculation of the merits and demerits of acquiescing to D's advances, V probably did not dwell on her stance to each individual aspect of the sexual encounter. She did not separately evaluate her attitude to each button undone, each individual touch, every caress, and every kiss. But of course, consent, at least to individual acts strictly necessary for the purpose of intercourse, is probably entailed by the overall consent. Additionally, maybe V implicitly consents to acts that she contemplates or expects. But that can't be the full story. Even people who've been in stable relationships for years may hope that sexual encounters will sometimes go beyond playing all the old hits. We might like some experimentation. The odd bit of surprise is probably healthier for the relationship than monotonous routine. Now, sometimes surprise moves will be unwelcome and will prompt objection. But some surprise moves, like those in this example, will be welcome. In the heat of the moment, it is exceedingly unlikely that much calculation will go into deciding whether a particular surprise is welcome. But even so, the surprise move and the welcome, when they are contemporaneous, then it seems appropriate to think of the surprising act as having been consensual, despite this consent not being implicit in some broader consent. The alternative, thinking of these acts as non-consensual but ratified, would mean that D actually commits a sexual offense and V chooses not to complain. That gets the phenomenology entirely wrong. It also means that in principle, D could be prosecuted regardless of V's ratification, since subsequent ratification can't undo a prior offense. If the contemporaneous welcoming of an unexpected surprise is consent, then this consent must have been given unreflectively and without deliberation. So, in surprise, the considered consent to the overall sexual encounter implies consent to the entailed and previously contemplated acts. Additionally, there is unreflective consent to surprising but nevertheless welcome acts. Now, consider the closest relationships and the most impulsive sexual encounters. Here, people may engage in little, if any, considered evaluation of their attitudes even to the entire sexual encounter. Now, this doesn't mean that they don't consent. It is just that their consent is unreflective rather than considered. To see how this helps us make progress, let us now look at how we define the effective scope of consent. We can do this by identifying the parameters of the object of our consent, or by setting preconditions for it to arise, or both. First, consider parameters. Say you like a bicycle that you've spotted in a shop. The shopkeeper consents to you sitting on it, testing the brakes, even ringing the bell, but she doesn't consent to you removing the price tag or adjusting the saddle height. Now, the shopkeeper can allow or disallow these things because by virtue of exercising autonomy over the bicycles in her shop, she gets to choose what to permit in relation to each of them. She gets, that is, to identify the object of her consent. In this case, the object of the shopkeeper's consent is described by reference to parameters like you may sit on the bicycle, you may test the brakes, you may not remove the price tag, you may not adjust the saddle height. And in fact, not only does the shopkeeper get to identify the object of her consent, she must necessarily do so because consent requires an object to make sense. One does not consent in the abstract. One can only consent to something. This is true also for someone exercising their sexual autonomy to consent to sexual activity. The consenter gets to, and indeed must, decide the object of her consent, what she consents to. And she does this by reference to various parameters that describe the bounds of her consent. So V gets to choose the parameters which describe the bounds of her consent, and so you might think, therefore, that V consents to D's actions if and only if those actions match V's mental description thereof. That would certainly maximize the protection of V's sexual autonomy by giving V absolute authority to frame the object of her consent. But there's a problem. Act descriptions such as this can be causally complex. They can specify that certain consequences should follow from the acts contemplated. So, adopting the approach that I've described might entail embracing the implausible proposition that if D chooses a causally complex act description, then subsequent events will dictate the precedent validity of her consent. The way to address this is to caveat that for the purposes of identifying non-consensual sexual wrongs against V, references in V's description to events subsequent to the sexual activity will be irrelevant, though they may be relevant to identifying other wrongs against V. And this caveat isn't ad hoc. In the context of sexual offences, our interest is in cases where a sexual act wrongs V. Where V's act description includes a sexual act and a subsequent event, and the subsequent event doesn't come to pass, V is really wronged by the fact that the subsequent event did not come to pass rather than by the sexual act. For instance, in a case called Lineker, V, a prostitute, agreed to have sex with D for £25 to be paid after the fact. D didn't pay. The trial judge instructed the jury that if, having had sexual intercourse, D decided not to pay, this would not vitiate V's consent to sex. The central wrong suffered by V on those facts would relate to D not paying rather than D having sex with her. As such, calling what V suffered a sexual offence would mislabel the wrong. This also explains why someone who consents to sex that results in impregnation is not the victim of a sexual offence when she doesn't fall pregnant. Now, sometimes an expectation as to subsequent events can be rephrased as a belief as to present circumstances, and perhaps such a belief could be incorporated into V's description of the sexual act. So, for instance, in Lineker, V could have had the belief that at all times during the sexual intercourse, D remained willing and able to pay the agreed price. If V had consented to sex with D, who is willing and able to pay £25 for sex, and D was unwilling or unable to do so, then, as the trial judge noted, that might mean that V had not consented to the sexual activity. But note two things. First, since V has the authority to frame the object of her consent, what matters is not what V could have done, but rather what she actually did. In other words, if V phrased her agreement to sex in terms of an expectation of later payment, then the fact that she could have rephrased it by reference to her present belief in D's willingness and ability to pay for sexual intercourse will not avail her. We're interested in consent as it was granted, not as it could have been granted. And second, even if in the Lineker example V had rephrased her consent as suggested, that would not make its validity contingent on subsequent events. While one could, on the revised statement of V's consent, convict D if he had never intended to pay, if, having intended to pay, D later changed his mind, a conviction would remain impossible. So in sum, the rule that best protects V's sexual autonomy in framing the object of her consent without tying the validity of her sexual consent to subsequent events is, V may frame the object of her consent however she wishes, but references in V's description to events subsequent to sexual activity are irrelevant to the law of sexual offences. Now here's a second problem. V can, in principle, identify the precise boundaries of the object of her consent by exhaustively listing each parameter thereof. Then reference to V's list of parameters would resolve any dispute about whether V's consent extended to some X. But in the context of consent to sex, such cases are vanishingly rare. More often, even when consideredly consenting, V frames the object of her consent by reference to a non-exhaustive list of key parameters. Now this list may well leave the issue of whether V's consent extended to X underdetermined. There would be a correct position on the issue, but just reading V's list wouldn't reveal it. Consider this example. Suppose Aisha consents to receiving a puppy to foster. She expressly restricts herself to fostering only puppies from a shelter, but like most people, she doesn't consider the possibility that puppies can have rabies. Now, reading a list of Aisha's express parameters does not tell us whether Aisha consents to fostering a rabid puppy from the shelter. Now, recall that sexual consent is often granted unreflectively. Since consent needs an object, it follows that it must also be possible to frame the object of one's sexual consent unreflectively. In such cases, even more such boundary disputes will be left underdetermined by V's list, such as it is, of parameters. So how do we determine whether V consented to X in such cases? Well, in the context of the puppy example, it's quite plausible to think that despite not having given any thought to the possibility of getting a rabid puppy, Aisha almost certainly didn't consent to fostering one. But why not? Is this restriction on her intent or consent implicit? Well, if by implicit you mean either entailed or unstated but nevertheless contemplated, no. It is possible to foster, however temporarily, a rabid puppy, so that restriction is not entailed, and ex hypothesi, Aisha did not contemplate the possibility of rabid puppies. But maybe each of these deal breakers, beliefs that if we knew were false, we would not consent, maybe each of those is an implicit restriction on what she consents to. But that too is implausible. Implicit but existent restrictions can't be identified by asking questions about counterfactual worlds. The answer to the question, would you have objected to X had you thought about it, tells us about restrictions that would have been set in a counterfactual world. It does not tell us about the restrictions that were set in this one. Instead, we should resolve disputes about the boundaries of the object of V's consent by asking what V was actually mentally picturing when consenting, whether this be a consideredly defined image or an unreflective sketch or a bit of both. So for instance, Aisha's requirement that the puppy come from a shelter is a consideredly selected parameter of the object of her consent. If, when framing her consent, Aisha was picturing a healthy puppy, so not one with distemper or rabies or a broken leg, then she unreflectively selected a parameter that ruled out rabid puppies, and based on our experience of people and absence of contrary indications and anything else, we probably believe Aisha when she claims to have done just this. I mean, after all, which prospective puppy parent pictures poorly pups? But if Aisha had claimed that she had also unreflectively selected a parameter to the effect that the puppy's nails be freshly trimmed, we'd probably find that a bit less believable. I mean, certainly her behavior would be unusual enough for us to demand corroboration of it. But then again, perhaps she could point to a persistent personal pattern of preoccupation with her pet's pedicures to provide this proof. Alternatively, Aisha could have specifically considered the matter and agreed to foster only a puppy with freshly trimmed nails. On those facts, we would have a consideredly defined object of her consent, which includes these parameters. Were this disputed, we might require Aisha to provide corroboration of her assertion that she consideredly selected this parameter, but seeking such corroboration is entirely routine. We think nothing of asking Aisha for proof that she only agreed to foster a puppy from a shelter if that was in dispute. Now, like in the puppy case, the parameters of the object of one's consent to sex can be selected consideredly or unreflectively when consenting. Only parameters actually in contemplation at the time will shape the object of consent. But there are two important differences between these cases. Firstly, as previously explained, since our interest is in identifying whether a sexual act wrongs V, parameters of the object of V's consent that refer to events subsequent to the sexual activity are irrelevant. And secondly, there might be a difference in how much thought goes into typical instances of fostering puppies and consenting to sex. Perhaps our decisions about the former might even be more considered than our decisions about the latter. So, when consenting unreflectively to sex, it seems less likely than in the puppy example that our picture of what we consent to will be detailed enough to factor in all or even most of our deal breakers. An HIV negative person might not factor in something as seemingly important as their prospective partner's HIV status when consenting unreflectively. Their consent may simply be to sex with that guy. This is why I think that proponents of subjective deal breakers views have hitherto overestimated the number of false beliefs that vitiate putative consent. While acts that fall outside the boundaries of the objects of our consent are not acts to which we have consented, we rarely, if ever, consideredly invoke all of our deal breakers when framing the boundaries of our consent. In fact, we regularly frame objects of our consent in an unreflective manner, or at least in part unreflectively, and so many acts featuring deal breakers are probably consensual. Conversely, some acts may fall outside the boundaries that we actually defined, either unreflectively or consideredly, and so they may be non-consensual even though the things that takes them outside those boundaries are non-deal breakers. Strictly, those acts are non-consensual. However, they are unlikely to generate protest given that the unexpected feature was not a deal breaker. Moreover, a person relying on putative consent of that sort would probably have a mens rea based answer to liability. Okay, let's return to our bicycle seller. Another way in which she can exercise her autonomy over the bicycle to set limits on her consent is by setting conditions that must be satisfied before her consent to the object thereof arises. For instance, she may say, you can take a test ride outside the shop provided you've left your credit card as a deposit. When setting a precondition for consent, one identifies a proposition and mentally links its truthfulness to the consent's validity. This mental linking isn't done automatically or instinctively. It's a considered mental act performed when giving consent. This implies that the concerned grant of consent must also have been considered. It follows, therefore, that the false belief as to the satisfaction of a supposed precondition can only defeat putative consent when we had granted the consent consideredly. Only then can we plausibly think that she also took the additional step of consideredly setting a precondition for her consent to arise. Of course, it's exceedingly unlikely that she took the extra considered step in respect of all deal breakers, but where V grants putative consent largely unreflectively, she probably did not set any preconditions. And again, all of this analysis also applies to persons exercising their sexual autonomy to consent to sexual activity. Now, many things that we may want in a sexual encounter can quite plausibly be packaged as either preconditions or parameters. For instance, consent to sex on the condition that a condom be used is a precondition, but it can be repackaged as consent to safe or protected sex. That would specify the parameter of the object of consent. Now, perhaps any precondition for consent can also be made a parameter of the object of consent and vice versa, especially since we've excluded subsequent events, which by definition can't be preconditions. Of course, in terms of our linguistic conventions, some things are more likely to be framed as preconditions than parameters and vice versa, but even in those cases, maybe one could perform the requisite mental gymnastics to repackage preconditions into parameters and vice versa. But I don't commit to a position on that issue here because actually everything turns on the way in which the object of the consent is actually described. Again, what matters is not what it is possible that the consenter did, but rather what the consenter actually did, and in the context of the criminal law, what a jury believes that the consenter actually did. As always, the evidence, including V's account of her thinking, the evidence of surrounding circumstances and so on, will guide our conclusions about what actually happened. Where it seems implausible that something was made a precondition rather than a parameter or vice versa, it will probably take more to convince a jury that V actually picked the implausible option. So if you're with me so far, you might still be wondering exactly when V sets the parameters for the object of, or preconditions for, her consent to a sexual encounter. In the paper, I discussed this by comparing two cases. Monica and Papadimitropoulos. I'll skip the detailed explanation here, but my proposal is that only parameters and preconditions that V sets when agreeing to the sexual intercourse succeed in limiting the effective scope of her consent. So if V held a false belief as to parameters set at this time, then she did not consent to what happened. If V held a false belief as to preconditions set at this time, then her consent did not arise. Now, to be clear, other false beliefs may still render the sexual activity consensual but tainted, and there's a case for criminalizing those activities separately, but it's not appropriate to consider applying the principle of the non-consensual sexual offences in such cases. Putting all of this together, we now have what I've called a refined model of when V's false beliefs as to deal breakers actually vitiate her putative consent. They do so when their falseness means either A, that what happened to V fell outside the consideredly or unreflectively selected boundaries of the object of V's consent, or B, that a precondition that V consideredly set for her consent had not been met, and V sets the boundaries of the object of and the preconditions for her consent at the time of agreeing to sexual activity. To apply this refined model, we need to know whether A, V consideredly made the satisfaction of the deal breaker a precondition for her consent to arise, or B, the deal breaker was one of the parameters by considered or unreflective reference to which V defined the object of her consent, or C, neither. Now, if either A or B is the case, we probably also need to know which. This may matter for D's mens rea. One can imagine circumstances in which it is more plausible for D to deny awareness of a parameter of the object of V's consent than a precondition for it, and vice versa. In sum, it will be challenging in real life for a tribunal of fact to ascertain whether something was genuinely a deal breaker for V, and if so, whether she made it relevant to her putative consent, and if so, how. But these challenges should not be overstated. The jury can make such findings, as it always does, by drawing inferences based on the evidence before it and the juror's experience of how people normally behave. In fact, there are several cases in which finders of fact have already done this when deciding similar questions. I've given examples in the paper. With adequate instruction, I think that the tests proposed here should not be beyond the ability of the average judge, lawyer, or jury to apply. We should therefore resist the temptation to adjust the rules in the refined model to make fact-finding easier. There is value, and not just intrinsic value, in trying to get the substantive rules exactly right, even if fact-finding proves challenging. Consider the background of Assange. The facts alleged occurred in Sweden, but D was in England. The Swedish authorities applied to have D extradited to face trial for rape, and under English law, D could be extradited if the material allegations would amount to an offence under both the law of the jurisdiction seeking extradition, so Sweden, and English law. Notice that in making this assessment, the English court has to refer to the allegations, since it cannot itself act as a fact finder. The refined model is well equipped to decide such cases, since it focuses on substantive legal rules and is not influenced by the challenges of fact finding. In the paper, I demonstrate how we can make plausible inferences about key facts and apply the refined model in a series of cases to reach intuitively appealing outcomes. I don't plan to go over these now, but I've set them out in my handout. And in addition to the cases that I mentioned in this presentation, I also address examples based on cases that people working in this field would recognize, cases like Monica, Lawrence, Devenald, and McNally. Of course, in the nature of this sort of enterprise, not everyone will share my outcome intuitions. But assuming that there are no major gaps in the internal logic of this paper, it would then appear that my interlocutors and I are at an intuition-based impasse. Fortunately, progress is possible if, instead of the binary agree-disagree metric, we employ a scalar metric that rates how plausible we find an outcome. So a reader who finds that when applied to these cases, the refined model generates most or many of their preferred outcomes and reaches outcomes that they consider plausible in respect of others, will still have reason to accept the refined model, at least until they find another model that better accommodates their preferred intuitions. So in conclusion then, the refined model operates by focusing not on the worthiness of V's chosen deal breakers, but rather on whether V actually exercised her sexual autonomy at the relevant time to use them in defining the effective scope of her consent. This means that it actively protects sexual autonomy without criminalizing every background white lie, every embellished fact, every half-truth that has ever nurtured a nascent relationship. And while I hope that you will share my intuitive preferences for the outcomes generated by my model, I'd be quite content if you thought that these outcomes were at least plausible enough to establish the plausibility of the refined model as a whole. Thanks very much for listening.